Thanks very much for coming to our Gender Roles conference. My name is Sharon Thompson, and following on from Lydia's brilliant paper, I'm going to be talking about whether or not methods in law are a feminist issue. So earlier this month I attended a Centre of Law and Society conference here at Cardiff, where Professor Roger Cotterill delivered a brilliant paper on the concept of values in socio-legal research. So he spoke about fundamental values such as the right to private property and how values like this can be challenged by practical legal issues. So the reason I mentioned Professor Cotterill's talk is because, interestingly, when the floor was open for questions, an audience member asked him how issues of power affect these values. So in other words, what makes particular values dominant and who decides what these values are? Professor Cotterill's response was that power does indeed play a part in which values dominate and who values may be imposed upon, but he had not mentioned this in his paper. Whether we choose to recognise it or not, gender is never absent from a discussion about where fundamental values in law come from, particularly when examining the wider context of social relationships in which values are constituted and accepted. The conversation changes depending on whether we choose to emphasise or to ignore gender, and so it is important to ask, what happens when a feminist approach is applied to legal methods, and are methods in law a feminist issue? So to be clear, in my view, feminism in this context provides us with tools that help us recognise particular inequalities. Feminism then is especially useful when thinking about power, because it directs critical fire at how social and legal structures create and reinforce power imbalances. By choosing to explicitly recognise this, in other words, to not be silent on the gendered dimensions of our work, issues of power are placed at the core of our discussions rather than on the margins. So even though the title of this conference is Gender Rules, the point of this really isn't to outline a collection of rules, but instead to suggest that feminist perspectives and gender-focused approaches are useful toolkits that we can use when building an analysis of law. Indeed, a feminist approach is certainly important when making gender visible in law, but does this mean that methods in law are a feminist issue? I want to address this question by considering why its answer might be no. So therefore, my starting point is to critically examine two challenges to the proposition that methods in law are feminist. Number one, although feminist perspectives are arguably relevant to some socio-legal methods, they are generally incompatible with doctrinal legal methodologies. And number two, even if methods in law are a feminist issue, a feminist approach is not always possible in practice. This argument might be made by our more conservative colleagues who think that attempts to reform laws in line with feminist aims is idealist, but it is also a criticism made by feminist scholars. So back to the first statement that feminist perspectives are only applicable to socio-legal methods, this raises a number of important points. For instance, can we really say that a feminist approach is relevant to the many and varied methodologies employed in law? At first glance, it is arguably quite a stretch to say that a doctrinal research project on contract law is gendered, but on closer inspection, as I hope to persuade you, a feminist approach is both relevant and beneficial to this type of research. Of course, offering a feminist perspective on any legal method can be complicated because there are so many different types of feminism. However, to be precise, I am distinguishing feminist research from research about gender. Research about gender does not have to use feminist legal theory at all. The reason I'm focusing on feminist legal theory in a conference about gender is because the strategies used by feminists in law were what inspired me to think about how gendered issues within my work should and could be emphasised. In the present context, I'm not referring to any one feminist perspective or saying that any one particular feminist theory must always be combined with legal method. Rather, I would suggest that legal methods are invariably gendered and therefore can be improved when a feminist approach is employed, as it is capable of recognising the political and social significance of these gendered dimensions. This is just as true for doctrinal studies in contract as it is for empirical research in family law. As Professor Joanne Connahan has put it, a feminist approach in these various methodological contexts is crucial in order to, quote, highlight the gendered assumptions embedded in legal and social arrangements, assumptions too often rendered invisible. From this perspective, a feminist approach forces us to look past masculine and feminine norms, which are generally reinforced in the courtroom, and to instead recognise the gendered realities of the social and legal relationships within our research. So as the focus on today is on research methods, I am going to talk about how feminist legal theory has inspired my work and how my methodological approach changed when making the gendered dimensions of my work explicit. My main research area is family law, and specifically the subject of prenuptial agreements, whereby couples sit down before marriage and set out in a contract what will happen to their property in the event of divorce. In recent years, there has been significant debate as to how much weight a prenuptial agreement should have on divorce, and whether it should be binding. I would suggest that one of the most interesting aspects of this debate is that it is divided between those who focus on the gendered dimension of prenuptial agreements and those who ignore it. Anyone familiar with the area will know that the most striking illustration of this is the 2010 Supreme Court case Radmacher and Granatino. Briefly, in the leading judgment, Lord Phillips said prenuptial agreements were to have decisive weight because it is important to give effect to the autonomous choices of the parties involved. In his opinion, autonomy meant essentially that the parties knew what they were signing, and gender had no role in this reasoning. The issues with this gender-neutral approach are highlighted in Lady Hale's dissent in this case. She chose to acknowledge the importance of gender to prenuptial agreements, to recognise that an assessment of these agreements is a feminist issue. So famously she asked, quote, would any self-respecting young woman sign up to an agreement which assumed that she would be the only one who might otherwise have a claim, thus placing no limit on the claims that might be made against her, and then limited her claim to a predetermined sum for each year of marriage, regardless of the circumstances, as if her wifely services were being bought by the year? So in this statement, Lady Hale is recognising that prenuptial agreements are gendered in their effect. And this is clear when the context of these agreements is examined. In the absence of a prenup, the judge has power to recognise the value of unpaid work in the home, such as reproductive or domestic labour, by making appropriate financial provision for the spouse who has undertaken this work. For obvious reasons, this is typically the lesser income producing spouse. However, my research and the work of others demonstrates that empirically, prenuptial agreements operate to contract out of any entitlements generated by non-financial contributions within marriage, including caregiving contributions, which are inevitably gendered. Unsurprisingly, it is the moneyed spouse that instigates a prenup with their partner. The dominant view seems to be that it is smart to protect your property from your spouse in a prenup, and the non-moneyed spouse is frequently characterised as a gold digger instead of a caregiver. This shows how, in reality, the discussion of dominant values mentioned earlier is not abstract or gender neutral. Indeed, the legal and social relationships between people are inherently gendered. However, this gendered power dimension is emphasised only when we frame the discussion as Lady Hale has. In short, a feminist perspective changes our view drastically. For me, Lord Phillips' analysis of the prenuptial relationship conjures up a monochrome painting of perfectly balanced scales that are framed and protected by procedures such as independent legal advice. When we interpret this legal relationship from a feminist perspective, the picture suddenly becomes chaotic, disordered, and is in bright technicolor because it depicts real people, real relationships, and importantly, the real issues with how power is exercised. So you might be wondering at this stage how this supports the argument that methods in law are a feminist issue more generally, After all, this research is socio-legal and fits comfortably under the umbrella of family law, which many commentators acknowledge has inextricable links with feminism. On the other hand, it is arguably more accurate to describe the coupling of feminism and family law as contradictory, because, as Professor Carl Zegler once put it, the equality of women and the institution of the family have long been at odds with each other. But there is an assumption that feminist legal theory is a more comfortable match with family law than with other areas, because research in this field frequently relies on socio-legal methods. I believe it is important to challenge this view because the feminist perspective is just as important to doctrinal method as it is to socio-legal method. In short, we need to have doctrinal analysis to lay the foundations for a feminist approach. As Professor Ambrina Manji has said, methods unanchored from doctrinal analysis do not get us very far. To illustrate, as part of my work on prenuptial agreements, I carried out a doctrinal analysis of vitiating factors in contract. In this area, using a feminist approach as a methodological tool completely transformed my perspective of contract and, in particular, the orthodox contractual emphasis on autonomy. In this context, autonomy is frequently based on assumptions without close examination of the actual relationship between the parties and of their respective bargaining positions. As I have already mentioned, a feminist lens questions traditional assumptions made in law and is equipped to recognise the empirical reality and particular ways in which power is exercised in relationships. This in turn provides an alternative analysis of traditional doctrinal concepts such as autonomy in contract law, and in the context of prenups uncovers the fact that power imbalances are not simply divided according to who has more money. As Professor Sandra Fredman puts it, neoliberal perspectives tend to emphasise women's freedom of choice instead of acknowledging the structural constraints on these choices and the impact social systems have on women's freedoms. But a feminist perspective can take us away from orthodox contract law's binary view of choice towards an understanding of the many and varied ways in which people really make decisions, and the social, economic and legal pressures they are under when making these decisions. So, returning to the first objection to methods in law being a feminist issue, I would suggest that feminism is a useful lens through which the law can be interpreted, even when the research methods are doctrinal. For instance, when examining legal relationships between parties, a feminist approach provides a refined set of tools that can recognise issues of power. This doesn't mean putting gender front and centre of every analysis, but it does mean that being sensitive to the role of gender in our work, however subtle, can only serve to enrich our approach. I now move on to the second challenge to the notion that legal methods are a feminist issue, which is that a feminist approach is not workable in reality. Certainly, as I have tried to argue so far, a feminist perspective is a very useful tool that we can use to criticise the law in many different areas. However, it is also important to assess the compatibility of feminism and law in practice. In her 1989 book, Feminism and the Power of Law, Carol Smart argues that resorting to law raises a dilemma for feminism because, as she has put it, the law is, quote, structured on patriarchal precedents, and so women risk invoking a power that will work against them rather than for them. Therefore, when we talk about the various gendered power imbalances that feminism pays critical attention to, it is crucial to also recognise that law, particularly common law, is in part responsible for these imbalances because it is based on gendered norms and assumptions. Put simply, if law is part of the problem, how can feminism operate within law to produce solutions? Perhaps the greatest challenge for a feminist methodological approach in law is for it to be consistent with and transformative of mechanisms of law in practice. To be frank, I am not prepared to conclude that the law is unable to recognise feminist concerns because it is patriarchal and phallocentric. I believe that clashes between feminist perspectives and application of the law in practice only happen when the law is interpreted and applied in a way that is detached from real social circumstances. Unfortunately, though, this is often what happens, and it can be a struggle to reform the law in line with feminist aims when the law is so frequently detached from these aims. But ultimately, it is a struggle worth pursuing, and one which could be aided by having more feminist judges. The Feminist Judgments Project, with which I know several people in this room have been closely involved, is a fantastic example of how legal precedents that have been previously interpreted according to gender-neutral and abstract assumptions can be rethought according to feminist perspectives. The importance in practice is acknowledged by Professor Jack Balkin, who has said that it is one thing to offer academic theories, but it is quite another to have to demonstrate that one's views are consistent with acceptable judicial performance. This process is not straightforward, and as Gibbon Amara have put it, quote, effective feminist interventions by members of the judiciary may require donning robes that are not entirely comfortable in order to persuade and advocate for change. Yet the feminist judging methodology shows us that far from being impotent, making feminist and gendered dimensions both visible and explicit in legal method is a meaningful exercise. At the same time, it is important to be sensitive to the constraints and limitations of law and to not be dismissive of Karl Smart's warning to feminism to avoid the siren call of law. But still, if we want to pursue a feminist agenda in legal research, we do need to think about how our methodological approach can be used and be clear about the benefits of feminist theory when investigating the role of law. We need to acknowledge in our work that methods in law are a feminist issue, because the law needs a feminist lens to recognise the structural problems underpinning it and to recognise the realities and nuances in legal and social relationships. Thank you.